And welcome to Legal Matters, everyone, an informational and news call-in show devoted to legal topics of interest to you, the State Line viewer. I'm your host, Alan Jones, and with me is attorney Michael Crosby with the Crosby Law Firm. We have attorneys standing by right now to take your call at the number on your screen as 815-397-2006. They'll provide you with free information on your issue. The call is confidential. So pick up the phone now and call the Crosby Law Firm throughout the next hour. Again, that phone number is 815-397-2006. Now, our opening statement for this episode of Legal Matters concerns planning in advance for your estate and making your passing easier on your family. Very important topics. In the second segment, we'll continue our popular You Want to Know question and answer session devoted to questions posed by you via telephone calls and social media. Again, the number is 815-397-2006. Lawyers are standing by now to take your confidential call. But before we get started, please note that the Crosby Law Firm represents thousands of individuals just like you. Just as our local hospitals handle a multitude of healthcare issues, the Crosby Law Firm can help you with a multitude of legal care matters as well. So pick up the phone. Call 815-397-2006. The Crosby Law Firm has a Center for Divorce and Family Law and Injury Department, which includes but is not limited to auto and motorcycle accidents, as well as a slip and fall medical malpractice, workers' compensation, and Social Security Disability Matters Department. There's also a Bankruptcy Institute, an Office for DUI, Traffic, and Criminal Defense, an Advanced Care Plan and Probate Center, and a division for real estate, business matters, and more. So again, feel free to call and discuss any of these practice areas with the attorneys standing by. Again, the number 815-397-2006. Lawyers are standing by now to take your call. It is free and it is confidential. Michael, welcome to the show. It's always a pleasure to have you.
Glad to be here. Thanks, Alan.
Well, for the month of July, we're talking about, it may be kind of a sad issue, but it's an important issue, and that's dealing with advanced care planning. Taking care of your estate after you pass, and the impact that might have emotionally and financially on your own family. And this is kind of a family time.
Sure. It's really, we refer to it as advanced care planning. Some of the planning that we do is pre-death, and some of the planning we do is post-death. And given that this is the month that we celebrate our independence, 4th of July, family get-togethers, picnics, so forth, this is really a topic, advanced care planning, that's a way for mom and dad, grandma and grandpa to give back to family, to make certain that there's an orderly passing of one's estate upon their death, and to make certain that things are covered in case of a disability, where they're injured or sick and can't carry on their own, so that somebody's there to carry on for them even while they're alive. So very important subject. Thought it'd be a good subject for the month of July.
Oh, sure. There's a lot of documents that go into it, a lot of things to cover, but what are the main documents, I suppose, when you're helping someone who really can't speak for themselves in many ways?
Sure. Pre-death planning, we take care of a healthcare power of attorney and a property power of attorney. So if one is disabled and can't conduct their own healthcare affairs, we have a document that they'll sign that designates a loved one, a family member that will step into their shoes and enable them to communicate with a doctor, with a hospital. That's a healthcare power of attorney. A property power of attorney, if you're disabled, still alive, will enable your loved one to take care of your business matters, your retirement account, Social Security, Medicare, your bank accounts, stocks, bonds, deal with your lawyer, etc. That's pre-death planning. And we do that as part of our advanced care plan. In a typical advanced care plan, there's about 8 basic documents. And as I've mentioned in prior shows, these documents are not driven by your age, so long as you're an adult, so 21 to 90, nor are they driven by your wealth, whether you're worth $1 or $1 million. There's basic documents in our society that everyone should have. So I'd encourage our viewers to give us a call, whether you're middle class folks, upper middle class, lower middle class, this is economically speaking. Everyone in our country needs a basic advanced care plan. We provide the free consultation. We charge a flat fee for this work. So I would encourage them to give us a call and come in and see us.
And that, you mentioned the economics of it and the assets and the net worth of the individual. That's probably a surprise to many people when they think estate planning or whatever, they must have an estate, but not necessarily so.
Very true. When you hear the word estate plan, it conjures up wealthy people.
Sure.
Nothing can be further from the truth. That's why one of the reasons we call it an advanced care plan. So middle class folks need a will, middle class folks need a health care power of attorney, a property power of attorney, a funeral and burial affidavit, a living will. There's just a variety of basic documents that we'll be happy as part of our law firm initiative, our way of giving back to the community. We've got these free consultations where we will share with everyone these basic documents and how they can benefit their family, and it's a way of giving back to their family. So the things are orderly upon their disability or upon their death.
And that's very important, to keep things orderly. As a reminder, don't forget the attorneys are standing by with your question at 815-397-2006, so give them the call. We talked about pre-death, after an individual has passed on, what documents, naturally a will, but what other information, what other documents may they need?
The will is the cornerstone of the advanced care plan once you've passed away. It designates someone to wrap up your affairs upon your death, commonly referred to as an executor, and it typically takes care of how you're going to pass on your assets to your loved ones. Another one that's relatively new in our state is a transfer on death instrument, acronym TODI, and it takes care of transferring your house to your loved ones, and it does not go through probate. It is a probate avoiding device that can save your estate upon your death tremendous amount of time, energy, and money. Again, relatively new in our state, been around for 3 or 4 years now, maybe a little longer. Again, be happy to share that information with the folks when they come in and visit with us.
That doesn't seem to be common knowledge, though. Is that fairly common?
It went into effect, I think, in 2012, 2013, so it's not common knowledge. There's still a lot of lawyers that don't do a lot of advanced care planning, that are not using the transfer and death instrument. It's a tremendously important document that can help a lot of families, save a lot of time, energy, and most importantly, money.
I guess so.
Avoid probate.
Yeah, I guess so. Okay, we're going to take a quick break. Again, that number to call is 815-397-2006. Stay tuned for our rapid fire You Want to Know question and answer segment coming up after we take a break. Make the phone call. And welcome back to Legal Matters, everyone. We're here with Michael Crosby, and we've been talking about the documents and the planning pre-death and post-death. Very important topic and very important information that families need to know about. One we didn't get to touch on was a living will. Talk about that a little bit.
Sure. A lot of our viewers out there may remember the Karen Ann Quinlan story over in the state of Michigan a number of years ago. That was a lady that did not have a living will and was on life support. Her family members wanted her to pass away gracefully. The state would not let that happen. So she laid in this vegetated state, if you will, for a long period of time. A living will avoids that. So if one doesn't want their surviving children, surviving spouse, to see them kind of wasting away in agony, if they're comatose, vegetated state, on a ventilator, so forth, a living will is a document that you sign when you're alive and in good shape. It's a directive that says, in the event my attending physician concludes that I will never recover, will never get better, please, to use a term of art, please pull the plug. Let me die with dignity and grace. It's a living will. It's a rather inexpensive document to prepare, but it can save the family a tremendous amount of emotional and financial expense. So a very important document, one of the key documents that we use in our advanced care plan, part of these 8 documents that I alluded to earlier.
Okay, in the portfolio.
Yes.
So yeah. for a better term right there, I guess, for a portfolio. Okay, well, now we're going to get into the question and answer segment. Do you want to know? In an effort to protect viewer confidentiality, understand we only use first names. We may alter the location and the nature of the question somewhat. I'd like to remind you the lawyers are still standing by to take your call, no matter the topic. Pick up the phone. The number again, 815-397-2006. So our first question for you tonight, Michael, comes from Vince in Winnebago. Good topic. My father passed away, and I found out I was named as executor in his will. What do I do now? What does that mean?
Well, it's a follow-up to what we've just been talking about. Vince, sorry for the passing of your dad. Typically, your dad, if he had worked with our firm, would have had a funeral and burial affidavit. That's one of the 8 documents that we prepare. that would direct you, Vince, on where your dad wanted to have the funeral, the burial arrangements, cemetery plot, so forth and so on. His will, once the funeral is taken care of in a timely fashion, the will needs to be recorded or filed at the courthouse. That's different from probating the will. So the will must be filed per the statute. In our office, when we're made aware of the passing of one of our clients, we have one of our clerks that will go to the courthouse and file the will automatically. So that's the first two things. Look at the funeral and burial affidavit to carry out your dad's last wishes regarding funeral and burial arrangements. Take care of filing the will. And at the risk of sounding somewhat self-serving, call a lawyer that is well-versed in advanced care planning and the administration of one's estate upon their demise, upon their death. We have a department devoted to this. A significant amount of our work in our office is devoted to advanced care plans and estate administration or probate work. I would encourage Vince to give us a call. Again, it's a free consultation. We'll be happy to sit with him and walk him through what needs to happen.
Okay, so he works with the attorney. The executor works with the attorney in making sure everything of the wishes of the deceased are carried out.
Exactly.
Basically so.
And that's critical. Some executors want to really roll up their sleeves and get involved with the process. Others are married, have their own children, want to move on with their own life. And so we'll listen to both kinds of clients. And those that want to delegate to our firm the role of an executor, we'll take that responsibility on. If you enjoy kind of getting involved with all that, you can do that as well. So it's a case by case in our office. There's a lot of liability and a lot of responsibility on an executor, both financial as well as emotional, dealing with your other surviving siblings that are there with you if your mom and dad have both passed. So Vince, give us a call. Be happy to help you.
Okay, walk through that. Next question from Genevieve in McChesney Park. She writes, several years ago, my husband was ordered to pay child support to his first wife for 2 children. Now the eldest is 18, out of high school. We've received a petition on the child support from the ex-wife, but don't know where to turn. We saw in the newspaper that the issue of support is different now. What are they facing? What's
The
the
law in
difference?
Illinois, good question, Genevieve. Law in Illinois has changed. In analyzing child support, we now take a look at both mom and dad's income to determine child support, not just the non-custodial parent. Both are taken into account. Secondly, 18 years old, graduate from high school, child support kind of morphs into what's traditionally called education support. So if Genevieve's child is off to college or vocational school or community college, tuition, room, board, books, so forth and so on, there can still be an obligation for both parents after a divorce to take care of their child's post-high school education support. So I'd encourage Genevieve to come in and see us. Be happy to sit down and chat with you about the parameters of this issue.
Great information. And Michael, we're running out of time, but thank you so much
You bet.
for being on the show.
Appreciate it. Thank you.
That's all the time we have with the Crosby Law Firm. Don't forget, lawyers are standing by for another half hour after the show airs at number 815-397-2006. We'll be right back with Mark Brunison and the American Law Firm in a moment. And welcome back to Legal Matters. I'm your host, Alan Jones. With me now is Mark Brunison, the managing attorney from the American Law Firm. This is a half-hour informational news call-in show devoted to a variety of legal topics. We have attorneys standing by right now to take your call at the number on your screen. They'll be able to provide you with free information regarding your legal issues. So call now and do so throughout the next hour. Our opening statement for this episode of Legal Matters concerns handling your own personal injury case. Mark has written a book on this matter, and he's got some great ideas on how you can handle your own personal injury case. Remember, the number to call is 815-394-1776, and lawyers are standing by right now to take your confidential telephone call. Mark, welcome to the program.
Good to see you.
Always a pleasure to see you and get great information. And like I said, you've written this book on handling your own personal injury cases. So talk a little bit about that.
Well, and I've said many times before, there are cases that an attorney shouldn't take, and there are ones that an attorney should take. But regardless of what class you're in, you should seek the advice of an attorney to understand the claims process and how to value the claim. And we do that for free, even if your case is not one that we feel is right for an attorney. And so I've written a book to help you sort of, and some questions to help you distinguish between those cases that an attorney should be involved in and one that they shouldn't be involved in, and also questions to ask the adjuster that gives you an idea if they're being fair with you or not.
Okay. What is the criteria for someone handling their own personal injury case?
Well, I generally look at this. Let's say personal injury, auto accident.
Okay.
I want to see probably at least $5,000 in property damage. Now that's flexible. It could be 4 or 5. I've seen cases where there's $2,500 in property damage and there was a death. But that's generally what we're looking for, and also about $5,000 in medical bills. And the medical bills have to be, in my view, you can go to the emergency room and not have any issues or symptoms the next day and have $5,000 in bills because you had a CAT scan and certain tests, but there's no injuries. So you have to, again, look at it and make sure that they're what I describe as treating meds, where you've had physical therapy, there was injury, and they had to treat the injury. So those are some things I look at, and those are the guidelines generally what I use to evaluate a case.
Okay, and some of the questions that have been included here, you call it the 11 questions to ask the insurance company
Yes.
who wants to just sign a few forms and give us a statement. Put that in quotes. The first question, will you put in writing about the accident? What will you put in writing about the accident?
Right, ask them, for instance, you're in the accident, the officer gives their insured a ticket. So when they call you up and you're handling it on your own, ask them, put in writing that you admit liability. Ask them to admit liability. They're not going to do it. They'll want a statement from you recorded, but they will not admit liability even if their insured got a ticket.
Okay. Will you tell me how much insurance the person who hit me has?
You'll never get that either. There is a state statute, if you're an attorney you know this, that you can write a letter to the insurance company even before suit's filed, and they have to give you a copy of the policy or what the limits are. And why is that important? Well, let's say you have a broken leg and you're going to lose a lot of time from work, and you know the damages, just the medical bills and lost wages, are going to be $40,000, $50,000. And the person has a minimal limits policy in Illinois, which is $20,000. It's not enough. And you need to know that to go over to your client's uninsured motorist to see if they have enough to cover that difference. Well, you're not going to know it unless you get that information. And you're not going to know there's a state statute out there that requires them to give you, the insurance company to give you that information. So that's just some of the small things that you need to know that an attorney would that you generally wouldn't.
Sure. Some of the small details
Right.
that go into the whole
But
thing.
the insurance company always tell you, I don't have to give you any of this.
Yeah.
No.
Okay. If I give a recorded statement, will you give me a copy of that statement that you already took from the person who caused the accident?
Generally, they won't. Now, anytime.
Why not?
Well, they don't want you to, well, they want your statement, but they don't want you to see what their insured said, because their insured may blow the case for them.
Yeah.
Right. And they may want a chance, and I say it's this way, you got to give the defense honest chance to lie their way out of it. That's what I say, OJ. They'll change their story. The adjuster will come up with some idiot theory of why your client was liable and they're not. Even though they had a green light, they were breathing too hard, or they were smoking a cigarette or something like that, even though their client made a left-hand turn, and they won't give you the information that'll hang their client. But yet, they want information from the poor person that was hurt to try to hang them.
Instead. Okay. Will you tell me how much money you have set aside in reserve to pay my claim? Talk about that a little bit. What does that mean?
That's huge. State law usually requires an insurance company, a liability carrier, when a claim is made, they have to go to their general fund where all their money is at and reserve an amount of money on your claim that they feel it could cost them. Okay. So they're always reserving money as claims come in, so they're not caught short. Well, if they were to tell you what that reserve amount is, that would tell you what the value of the claim, and they don't want you to know it. And they're always going to try to give you, especially if you're handling the case on your own, they're always going to offer probably 10-15% of the reserve, where an attorney is going to eat into that reserve significantly. But you ask them, what's the reserve? They're not going to tell you because they don't want you to know what they feel the claim's really worth.
Okay.
I can't tell you how many times I have clients come in and they say they have $10,000 in bills and the insurance company's offered $2,000 in full and final settlement. Think about that.
All right. Well, we'll think about that. We'll take a break, and we'll be back with Mark Burnison and more from the American law firm in a moment. Don't forget, lawyers are standing by for another half hour after the show airs. That number to call, 815-394-1776. We'll be right back. And welcome back, everyone. I'm your host, Alan Jones. With me, attorney Mark Burnison with the American Law Firm. And you're watching Legal Matters, an informational and news call-in show devoted to a variety of legal topics. As a reminder, attorneys are standing by now to take your call at the number on your screen, 815-394-1776. They'll provide you with free information on your issue. The call is confidential, so pick up the phone and call the American Law Firm throughout the next hour. Again, the number 815-394-1776. And we're talking with Mark about handling your own personal injury case. And he's written a book, and there are 11 questions in there about talking to the insurance company, getting the information that's necessary for that. We've run through quite a few.
Or finding out if they're being fair with you.
Or finding out if they're being fair. This one sounds interesting. Will you tell me whether you've already done video surveillance of me? That sounds an awful lot like Big Brother right there, but I suppose if you are filing a case, they're going to follow you.
Oh, yeah.
And record your movements.
The minute that happens, it starts with them. There's a database, and if they haven't changed the name, I think it's ISO 9000, where all the insurance companies, liability insurance companies, they'll always put into this data bank. So if you're insurance company A, insurance company B, they put all the information. If you were in 2 accidents, they'll put that in there. So they control that database and find out if you've been in other accidents, you've had other injuries, workers' comp injuries. Mm-hmm. They want to know if you've had similar type of injury. So the minute you file the claim with the insurance company of the person that hit you, they're already finding out about you. And part of that is they will come and videotape. If they feel that you've had other injuries, or they think you're playing around or faking, especially if you have a lost wage claim, they'll have a private investigator come out and videotape you playing with your kids water skiing when you say you can't work. And that's what you got to watch for. And that can happen innocently, where you're doing things as a dad or a mom. I mean, you don't stop being a dad or mom because you're hurt, and they'll try to take advantage of that, and that's the key.
So innocent movement,
yes,
can be videotaped and said, see?
Yep, but you could be in severe pain when you're doing
it. At the process.
That's right.
So, that's interesting. That's kind of scary, but interesting also. Will you give me a copy of any index information that you already have from your computer system? Is that what you were just talking about?
That's what I was just talking about. Okay. Let's say they go out and they do a database search, especially now with Google and et cetera. There is so many things out there, and there are specific databases that all the insurance companies have agreed to contribute to, where they can pull information out on you. There's so much information out on the web about you personally, and they troll it. They go out there and they find it, and they're going to use it against you, even if it's not relevant.
And that's where social media comes into it as well.
Oh, absolutely. Your Facebook page. In one of my books, I wrote this: if you're making a claim where you can't work, and then you post on Facebook that you just climbed Mount Everest, and then you're making a claim where you can't work, they're going to find that. In fact, I just had a deposition recently where they pulled out a bunch of Facebook information on my client and started going through it and said, here. And they were bowling with their kid. They were holding a bowling ball at a birthday party. Issue was, my client didn't bowl because they were hurting. And all the people could say that, but they were trying to give the impression you're out partying and you're saying you're hurting. No, not the truth. So things out of context, absolutely, you got to watch for it.
Okay. And I think that would carry some weight.
Oh,
I mean,
yeah.
Someone holding a bowling ball, you kind of assume, yeah, they're bowling,
yeah,
but not necessarily.
Until you can have all the 10 adults that were there that say they didn't bowl.
Yeah. And that's where it continues to grow a little bit. Will you give me a copy of any financial information that you may have already obtained?
Sure. There may be public information about your finances out on the web and here's where that comes into play. Insurance companies know, especially with what happened in the economy the last several years, people are hurting. So if you're in an accident and you can't hurt in the bill collector and you're 3 months behind, which is usually the trigger for a foreclosure on a house, they know that. So they're going to come out and put a lowball offer even though you're not done treating, and they're going to try to get you to take less than what your claim's worth by using financial information that shows you're in a world of hurt against you. And it's there, they can use it, they'll interview friends, they'll go interview co-employees. I've even had cases when I was in Virginia where they would get private investigators to go to a bar and act like the friend of a employee that was a good friend of my client. I mean, what they will do, the level they will stoop to is, you just can't imagine.
And I would imagine if someone is in financial difficulty, either because of the accident or whatever, how tempting that would be. Regardless, I mean, even if they know it's a lowball offer,
Well,
or maybe they don't even know that, but just the idea that I'm going to give you a bunch of money, go ahead and take it. How sweet would that be?
Well, the key is, let's say the claim's worth $100,000, but your house is going into foreclosure, and you can take $10,000 and redeem it.
Yeah.
You know,
Yeah.
but there are things that we can do as attorneys if somebody's representing themselves, and if you're in that boat, if you hire us, there are things that we can do to try to put that off. There are certain things that we can do to throw the monkey wrench in the foreclosure or the credit card suit that's against you for not paying.
Yeah.
There are things we can do if only we're consulted. So that's one good reason, even if you're handling a case on your own, come and see us.
Yeah. And the emotional part of it too.
Oh, absolutely.
I mean, playing on the emotions has got to be the key. Right there.
Your child can't go play soccer because you can't pay this, that, and they play that
Oh,
game.
I'm sure.
I've had people come in and they're just devastated because they don't have the money to pay for things they want their children to do.
Oh yeah, absolutely.
And
Great.
wave the dollars.
Yeah, yeah. All right, great information. Mark Brennison, the American Law Firm, thanks so much. Appreciate it. The topic, once again, lawyers from the American Law Firm standing by now to take your call. No matter the topic, the advice is free. 815-394-1776. Attorneys standing by for another half hour after the airing of the show. Be back with a closing statement when Legal Matters returns.
Legal Matters has been brought to you by the Crosby Law Firm and American Law Firm.
Attorneys for the American Law Firm and the Crosby Law Firm will be taking calls for another half hour after the show ends. If you get a busy signal or go to voicemail, keep trying or leave a message. Someone from either law firm will return your call the next business day. That's our Legal Matters program. We hope you found it informative.